David is a lawyer practicing law for over 20 years. He's accredited as a family mediator and collaborative legal professional. A collaborative legal professional is one that is looking to resolve issues without necessarily without going to trial. And I think it's very important, particularly in the family law realm, that there's people that are experienced and dedicated to trying to resolve things that way. David has been a passionate advocate for legal reform and spoken about the legal system and its intersection with human sex trafficking and family violence. So, David, thank you very much for being with us tonight, and I'll turn it over to you.
First of all, thank you very much, Rob, for asking me to speak alongside with such an incredible panel of advocates and experts. I'm going to start my clock too. And thank you to this group for providing such diverse and enlightening information. And I know that there are more out there. Some of you may be watching who are doing the same. So thank you very much for what you do as well. Something like this requires a community collaborative effort. And as I begin, I'm reminded by the words you see behind me, it starts with me. So just a bit about me. I'm David Morneau, and I have been very fortunate to work as a family lawyer in this community for nearly 25 years now. You will note that I embrace reform and innovation, which is needed in many of our systems. That said, I'll stick to what I know tonight and talk about the intersection between family law and family violence and family law. So my intention is ambitious here, I'll be honest, and I hope to provide as much as I can in the allotted time. This is definitely meant to be high level, and my plan is to cover first defining family violence and its application in family law, and then working towards a safer justice system. So let's begin with defining family violence and its application in family law. So, although there had long been an intersection between domestic violence and family law, it wasn't until 2021 that the federal and provincial governments legislated an actual definition. Prior to this, the approach was more or less we will know it when we see it, which usually meant that there had to be some level of police involvement, police reports, charges, convictions, medical reports, or an eyewitness. In that it didn't really pay much attention to what some, including myself and what I heard Sarah say earlier, believe is the more insidious form of violence and coercive control. And then we came to sections 2 sub 1 of the Divorce Act and 18 sub 1 and sub 2 of the Children's Law Reform Act, which created almost identical definitions at both levels of government, identifying family violence as any conduct, whether or not it constitutes a criminal offense, by a family member towards another family member that is violent or threatening or constitutes a pattern of coercive and controlling behavior, or that causes that other family member to fear for their own safety or that of another person. And in the case of a child, the direct or indirect exposure to such conduct. So this was the most expansive definition that the family justice system had ever seen and crystallized different forms of violence as well, including physical, sexual, psychological, and financial abuse, forced confinement, harassment, stalking, threats to kill or cause bodily harm to a person, and threats to kill or harm an animal or damage property, or actually doing so, because these were identified through the research as antecedents of escalating levels of violence, that we needed to recognize these things, even though they didn't involve an individual. It was important to recognize what the research was telling us. So then, applying this definition, the legislators analyze factors to be considered when determining what is in the best interests of the child, where we are directed to look at family violence and its impact. And then finally, in this analysis, we are guided to look at factors relating to the impact of family violence, including its nature, seriousness, and frequency, patterns of coercive and controlling behavior, whether the violence is directed towards the child or the child is directly or indirectly exposed to the violence, physical, emotional, and psychological harm or risk of harm to the child, any compromise to the safety of the child or other family member. And then it asks questions like, does the child or other family member fear for their own safety or the safety of the other person? Have steps been taken by the causer of harm to prevent further violence and improve their ability to care for the needs of the child? And then, Rob, as we're used to in law, the any other relevant factor, which leaves it open, at least for research as it develops, for courts to identify things where there may be gaps in the law. Now, I'll definitely say that this definition and its application are not perfect, but when you compare it to the fact that we didn't have any guidance at all before this is a huge step. So creating the definition and acknowledging the behavior and its impact is important, but those who have witnessed or experienced family courts may attest the system can be violent and incendiary. It's adversarial in nature and tends to be zero-sum in its approach. The system tends to be retributive, punitive, and reactive, which, from my perspective, can actually cause more danger. Uh, it doesn't encourage accountability for fear of consequences. The system is predicated on this concept of winning, whatever that means. And quite frankly, despite its best intentions, the system can lack expertise, particularly when it comes to violence. And this is an interesting tidbit that many people don't know. Certainly, people who aren't, even people who are in the legal profession, that in Ontario, an accredited family mediator and most collaborative professionals are required to have extensive and ongoing intimate partner violence and coercive control training. But lawyers operating within the court system, which, based on my observations, I would argue tends to be higher emotion and conflict, do not. And I want you to think about that for a moment. This is not meant to espouse one means of resolution over another. What I'm trying to do is underscore and illustrate a significant deficiency that, from my perspective, is entirely correctable. And even judges were not required to have specialized training until Kira's Law, which is Bill C-233, named after 4-year-old Kira Kagan, who was killed by her father during a visit. This is now passed Senate and will require judges to have current and ongoing training for intimate partner violence and coercive control. In Kira's situation, there were an abundance of red flags, and Jennifer and I have become acquaintances and friends as time has gone on. Kira's father demonstrated, Jen Hutton had referred to risk factors, 22 risk factors, which risk factors, if there's proper domestic violence screening within the court process, can be recognized and acknowledged. And separation is actually one of the risk factors, and not, from what I've seen in my career, actually can escalate the potential for violence. He had 22. 7 or higher would suggest that a death is predictable and preventable. He had 3 times that amount. So I took and I continue to take ongoing training in intimate partner violence and coercive control, and can say that I learned so much, including I didn't know what I didn't know, which I think is sometimes more important than what we do know, which led me to connect with the various resources in our communities and beyond. Proper education and thoughtful planning is essential. I've been very, very vocal and unequivocal that everyone working within the family justice system needs this training, whether they're in court or not. And then there are some other emerging areas of violence and concern, including the growth in litigation abuse, the impact on children who have experienced violence, including becoming victims or causers of harm themselves, serious illness and premature death as adults, which again is not something that necessarily is on the radar, but there's plenty of evidence and research to demonstrate the correlative connection between the two. And for that, I just want to stop and pause and thank the Child Witness Center. I know that a couple are, I think Robin and Ryan are out there, for providing me with some of this information for this presentation, and for what they do for children in our communities. And if you don't know who they are, please look them up. They're a vital resource for children who have experienced violence in our communities. And then there's also post separation abuse, which Jen, I'm sure everybody sitting on this panel has seen as well. And what I would say is, if you have a chance, take a look. This post-separation abuse wheel is available in different colors and online, but it talks about the different areas where abuse can be applied in the separation context. So, all that said, we're an intelligent community. The change and making things safer is completely within our grasp. You know, if I see myself as the person that helps to start the conversation, I'm happy to share my ideas within the family justice system and how we can make it better for anyone who might be interested. I'll put up my contact information in a second. And I've also left some resource materials with Reagan if anybody's interested as well. Plug for myself, I can put together customized educational programs around navigating conflict. It's not just limited to separation and divorce, although I've done quite a bit of that. But all of this is meant to empower. We need to move to a stage where we're empowering more. And again, if anybody's interested, there's my contact info. And with that, I just want to say thank you for listening, and thank you for everything that everybody does.
Thank you, Dave. I know there's a lot of stuff in there, and I appreciate you going through that, and also the information about offering your resources as an education source. You know, I can certainly imagine some places that would like to have someone like yourself come in and help educate their people. I just wanted to touch base. It's going to sort of combine the question from Charlotte about mediation. It's that whole thing about trial, and you and I know. I mean, nobody wants to go to trial generally, because it's such an intense experience, as you mentioned, and the potential harms that come from that too, and so much stress. And Charlotte was asked to pose the question. She thought everything was going to 100% mediation. What is the trend, or what's in the system overall with respect to trying to find an alternative way to resolve issues?
Sure. So first of all, I just wanted to correct Rob. Collaborative family law is its own process. It's
Right.
self-contained. It's outside of court. So you have to commit to that process. And what we've done is we involve lawyers don't like including other people. We involve family professionals and financial professionals. We bring them in. The idea is to work as a team, and it actually, in those circumstances. So now to the question, Charlotte's question about mediation, we're not moving towards 100% mediation. Now the law has changed things to recognize that mediation, when appropriate, should be canvassed by the legal advisor. What people fail to realize is that sometimes court is absolutely necessary. There is just no getting around it, but it shouldn't be the automatic in intimate partner violence and coercive control cases, because there is so much that can be done in a well-constructed process outside of the court that actually alleviates danger. And you actually have professionals who are attuned to um, screening and have ongoing training for intimate partner violence and domestic violence, or in coercive control. But we need to get away. People often think, well, there's violence here, it needs to go to court. The professionals outside the court system are actually more readily trained in that area and
Right.
ready to deal with it and bring in the right professionals to help people get through that, and get to where they need to go and move on with their lives.
Okay. All right, Dave. Thank you very much for that.